Senator, what you want to do?
Is this working at all?
Yes, it is.
Okay, we're going to go ahead and get started. I'd like to welcome everybody here. This is the third and last leg of 3 public hearings that we've held. We held a public hearing last night in Greenville on this particular bill. We held one in Columbia this morning, and now we're happy to be in North Charleston this evening. And before we start, what I'd like to do is ask my colleague to the left here, Senator Kevin Johnson from Clarendon, to say a blessing.
Thank you, Mr. Chairman. Let us pray. Heavenly Father, once again, we want to come to you and thank you for the many blessings that you have bestowed upon us. Father, we don't come asking for anything, but just thank you for everything that you've already done. Thank you for allowing us to serve in the capacities that we serve. Thank you for allowing us to gather together with our citizens to discuss a very important issue, an issue that's important to the citizens and to the state legislature. We ask, Father, that you continue to guide all of our thoughts and our words and our acts, and let everything that we do be pleasing in our sight. We ask, Father, for traveling mercies as we depart from here tonight at the end of this meeting, and that everyone will arrive back to their destinations safely. These and all blessings we ask in the name of our Savior, Jesus Christ. Amen.
Amen. And I'd ask my friend on the right, Senator Bryant, to lead us in the pledge.
Stand, please. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, we'll go ahead and get down to business. First, some introductions. My name is Tom Davis. I'm the state senator for District 46, which is the city of Beaufort, Bluffton, Hilton Head, and Beaufort County, and also part of Jasper County. To my right is Senator Kevin Bryant from Anderson County. To my left is Senator Kevin Johnson from Clarendon County. I think we're going to have a couple other senators making the way. I see one right now from Horry County. Senator Greg Embry is here. And I think we have 1 or 2 others coming. The other members of this committee are Senator Thomas McElveen from Sumter County and Senator John Matthews from Orangeburg County. And the reason we're here, and the task that we've been charged with, our committee, is to consider and to look at the legal and constitutional aspects of a bill that passed the House of Representatives last year, designated H3101. That dealt with the Patient Protection and the Affordable Care Act, how that particular federal act gets implemented in South Carolina, and some conditions and restrictions on its implementation. That particular bill, H3101, went through the House committee process. It went to the subcommittee. It was sponsored by Bill Chumley. It went through the subcommittee in the House, a full committee in the House of Representatives, and then it was voted on by the entire House and passed and sent to the Senate. And it crossed over to us in mid-May. And as you know, the session ends the first Thursday in June, so we didn't have the bill but for about 3 or 4 weeks. But during that 3 or 4 weeks, those of us who felt that it was important to consider that bill agitated and arranged to have that bill placed on what's called special order in the Senate. And ordinarily, when a bill crosses over from the House to the Senate, It gets assigned to a subcommittee. After a subcommittee hearing, it gets a full committee hearing. Then it goes on the Senate calendar, and it gets taken up in the order that it gets put on the calendar. And a lot of times that can take months because there can be bills ahead of it. This particular bill, H3101, got pulled out of subcommittee, placed on the Senate calendar in what's called special order status, which means it's up for debate. And it's going to be taken up for debate by the South Carolina State Senate when we reconvene in January, right after the ethics bill. So the very first two items of business when we reconvene next January is the ethics bill and then H3101. So knowing that this bill was going to be debated early in the session, the President of the Senate, John Corson, appointed a committee to look at this bill because it didn't go through the subcommittee and the committee process. It appointed us as a select committee to look at H3101, to understand what it purports to do, to ask ourselves the question of whether it's constitutional or illegal, and if so, what would be the impact. And so that's what we're doing. This is the first step in a process of being able to report back to the Senate in January what this particular bill does. And what we've done so far is heard public testimony in Greenville and in Columbia and now tonight in North Charleston. After that, we're going to receive, at some point, in some form, some expert testimony from constitutional scholars, academics, professors, and again, the idea being to come up with something that is legal and constitutional and accomplishes the objectives that the Senate desires. Now, what I'd like to do is this. I'm going to give a brief summary of what H3101 that passed the House does. And then after I do that, I'm going to go ahead and let my colleagues make whatever introductory comments they want to make in regard to what we're doing here this evening and in regard to the bill. But then I want to yield the balance of the time to you guys to receive testimony for the balance of the time, because that's the real purpose of this meeting, is to hear from the public some real-life stories, some opinions from you about the Affordable Care Act, how it affects your life, either for the better or for the worse, so that we have an ability to make an informed decision on your behalf next January when we reconvene. Now, let me go through what H3101, as passed by the House of Representatives and as currently on the calendar in the Senate, does. Okay, so I think it's very important to talk about that first. First of all, hey Thomas, you can see. This is Thomas McElveen from Sumter County.
Not Senator Matthews.
Not Senator Matthews. The first thing H3101 does is it codifies what I would call the PRINZ rule. That's P-R-I-N-Z. And that's based on a United States Supreme Court case that took up the Brady bill, the Brady gun control bill. And that particular bill, one of its components was directives to the states and to the states' political subdivisions to enforce the federal law. It told state officials and county officials how to implement that federal law. And it was challenged, and it was challenged on this basis, that states aren't merely political subdivisions of the federal government convenient to the implementation of its laws, that they are sovereign, that the states are not just administrative units, and therefore, even though Congress may pass a law, and even though it may be constitutional, it cannot be, the states cannot be compelled to spend its money and to direct its employees and agencies to carry out its terms. That's what the first part of H3101 says. It says that the Affordable Care Act, passed by Congress, even assuming that it's constitutional, which many argue that it isn't, but assuming that it is, that we are not going to have any state employee spend money implementing it. We're not going to have state money spent implementing it. And so I call it the PRINZ provision of the particular bill. So think of it in those terms if it's helpful. That's the first part of what H3101 does. The second thing that H3101 does is it directs, or directs is too strong a term, it suggests to the State Attorney General, Alan Wilson, that if in the implementation of the Affordable Care Act, if in his opinion there is any negative or harmful effect on South Carolina residents, that he institute proceedings in federal court to challenge or modify those regulations of that implementation. Now, it is suggestive as opposed to directive because, as you know, we have three branches of government. And the legislature makes the law and the executive branch enforces the law. The Attorney General is part of the executive branch, and we are not in a position as a General Assembly to tell a member of the executive branch what it must do. So the second part of H. 3101 is suggestive to the Attorney General in terms of taking legal action that he believes may be harmful to South Carolina residents in the implementation of the Affordable Care Act. The third thing that H. 3101 does, it creates a new state tax exemption. Many of you are aware of one of the key, probably the crux of the Affordable Care Act are the mandates. The individual mandate that compels individuals to purchase insurance, and the employer mandates, which require certain employers to provide insurance for their employees. This third part of H. 3101 says that to the extent that an individual or a business does not comply with that mandate by the Affordable Care Act, and if they are then fined or taxed, as the U.S. Supreme Court characterized it, if they are taxed in terms of a penalty for not complying with that mandate, that individual who is so taxed or fined has the ability to take a tax deduction on their state taxes to make themselves whole. Okay, so that's what the third provision of H. 3101 does. And then the fourth one relates to another key component of the Affordable Care Act, which is the creation of state health care exchanges. I mean, that's the vehicle through which the IRS levies fines or taxes against individuals who don't comply with the mandate to come up with money that then funds the ability of the exchanges to provide subsidies for insurance policies. Now, there's some debate right now, and there's a lawsuit that's been brought by the Attorney General in Oklahoma that says that the terms of the Affordable Care Act provide that only state-created exchanges, only through state-created exchanges, can the IRS levy that penalty and issue those subsidies. The IRS takes the position that in the event the state doesn't create a health care exchange, the federal government can come in and create that exchange, and the IRS can still levy those fines and issue those subsidies. In any event, the fourth part of H. 3101 is a directive that there shall be no state-run exchanges created in South Carolina. There currently have not been. Governor Haley has decided to decree that we should not create those exchanges, so we currently have none. But this would make it the official policy and legislative policy of the state of South Carolina that no municipality, no county, no political subdivision, and no state agency or the state itself would create a health care exchange under the meaning of the Affordable Care Act. Those are the four things that H. 3101 does. That Prince rule that I talked about in regard to the use of state resources to implement a federal law, the directive or suggestion to the Attorney General in regard to commencing legal actions to challenge any Affordable Care Act implementation that harms South Carolinians, the tax deduction that I talked about in case somebody is fined for not complying with the mandate, and then the directive that there shall be no exchanges created by the state of South Carolina. Those are the four things that H. 3101 does. Now notice what H. 3101 does not do, because I think it's very important for clarity and in terms of considering what's before us. It does not nullify the Affordable Care Act in the sense that a lot of us may think about nullification. I mean, it's the way I think about nullification is, for instance, what John C. Calhoun in South Carolina did in 1831 when they declared that they were not going to recognize the tariffs that the federal government was levying against their industries or against their citizens. And Andrew Jackson and South Carolina almost came to blows over that. That was a state declaring a federal law would not be enforced within its state boundaries. And we can debate whether or not that's a good idea or a bad idea, and I'm sure tonight people have opinions on that, and I welcome hearing them. But what I want to point out right now, before us right now, and what was passed by the House in H. 3101 does not involve a nullification of the Affordable Care Act in that sense. So having said all that, what I want to do now is yield to some of my colleagues over here and have them say a few words, and then I want to get right on to the list of people who have signed up to speak so that we can hear information from you. And I'll start with my far right, Senator Appleby.
Good evening, everybody. I'm Thomas McElveen. I've been serving in the Senate for about a year now. I represent District 35, which is Sumter, Kershaw, Richland, and Lee counties. And it's a pleasure to be here in Charleston tonight. This group here has crisscrossed the state in the last couple of days, last 24 hours really. And it was good to get out and hear from people, and we're looking forward to having some degree conference tonight on this. Thank you all for taking the time to get out here on a Wednesday night after work, and it's good to see everybody.
Good evening, everybody. I'm Greg Hembry. I'm from Senate District 28. That is a little part of Dillon County and about half of independent Republic of Horry County. I live in the North Myrtle Beach area. It's a blessing to be with you tonight. We have, as Senator McElwain stated, we've been in Greenville. We're in Columbia this morning, now in North Charleston. It's been a bit of a whirlwind tour, but I must tell you that it has been a real pleasure to hear from the citizens of our state. We have heard passionate debate and argument on both sides of this important issue. We've had, although we've had passionate discussions, we've had very respectful discussions, and it has been a real testament to the spirit of the people of South Carolina that even though we might feel strongly about something, we've got good manners when we express those opinions, and that really has been kind of a good example to us senators. So with that, I look forward to learning from you tonight, hearing from you tonight. Thank you for hosting us.
Thank you, Mr. Chairman. My name is Kevin Bryant, and I represent Anderson County in the upstate in South Carolina Senate District 40. And I think it can't be expressed enough on how exciting it is to see the folks like you coming out. I know you're busy. I know you're taking time out of your schedule to come and participate in this. And it's just exciting that we live in a country where we can have a free, open exchange of ideas. And I appreciate y'all for being here.
Thank you, Mr. Chairman. Good evening, everybody. I'm Senator Kevin Johnson, Senate District 36, which includes all of Clarendon County and portions of Sumter, Florence, and Darlington counties. And I, too, am pleased to have the opportunity to serve on this committee and to be here to hear your comments, hear you express your concerns and your issues as it relates to House Bill 3101. I know exactly how I feel about 3101, but it'd be good to find out how you feel about it. And I'm going to reserve further comments until later, but it's good to be here. And as was mentioned earlier, this is our third stop on this tour that we started this time yesterday, and the discussion has been very lively. It's been very passionate, but it's been very orderly and very respectful. And so we're learning, and I still contend that although some of my colleagues say this is not a nullification bill, and it may not be, but as I have said before, the end result of this bill passes will be nullification, I think, of Obamacare. And I notice that most of the folks who have come out and have spoken in favor of this bill are wearing buttons and name tags that says nullification or nullify Obamacare. So I feel like they agree with that also. But we're here to listen and to get facts, because at some point we're going to have to report back to the full Senate, mainly on, in my opinion, the constitutionality of 3101. So we look forward to hearing from you, and I know the chairman is eager to start that process, so I'll be quiet and let us move on to hearing from you. Thank you very much. Thank you, Senator.
All right, let's get right into the public comment. Esther Lappin, I'm sorry. And what I'm going to try to do is limit our comments to 5 minutes. We have 25 people who have signed up, and doing the math in my head, that takes us right through to about 8 o'clock. So, but if you go a little bit over, we're not going to jump down there and haul you down. So, yes, ma'am, go ahead.
Okay, all right. Once again, my home state is proving herself unwilling and unable to join the 21st century, as she still has her mind in the 19th century, when this state led a losing and bloody fight in the Civil War and yet continues to wage it. Plantation days are deservedly gone with the wind, but the mindset persists to our detriment. Basic benefits of living in a society do not belong to the privileged or to the few, not in this country and not in this century. As the rest of our industrialized allies realized and implemented long ago, access to affordable health care is a must-have for any successful government or any progressive society. It is as important as access to public education, and it is up to the government to provide these much-needed services that benefit all U.S. citizens. The private sector, driven by profits only, with little to no regard for the impact of its decisions on the public, is not the answer. How, in good conscience, could a company deny health coverage at an affordable price to someone with a pre-existing condition? Being born is a pre-existing condition. When you reduce everything to a line item on a profit and loss statement, you value nothing. The Affordable Care Act is not a favorite of mine because it did not go far enough. I wanted then and still want a single-payer plan. For those afraid of government intervention, look to the Veterans Administration, America's socialized medicine. I don't hear anyone talking about reducing or invalidating health care to our veterans or criticizing the VA's providing socialized medicine. All U.S. citizens deserve access to affordable health care without regard to insurance companies' restrictions like pre-existing conditions, congenital health issues, lifetime caps for payments, or simply being a woman. Given that the Affordable Care Act is the law of the land, and given the judicial history against nullification attempts, I find this in similar meetings throughout the state an affront to intelligence, to decency, to civic responsibility, and a huge waste of time. If you are using taxpayers' dollars for your time and mileage, etc., for these meetings, please stop. You legislators should be creating and not destroying. You should be coming up with ideas that benefit the state and her citizens, not just a few of us. The intent of the Affordable Care Act is valid, and your efforts should be directed to improving it. When the majority of bankruptcies filed in this country have basis in medical debts, it is past time to recognize that a healthy society is a thriving society. Perspectives differ, and for those of us wanting to move forward, it's galling that others among us have the yo-yo perspective of this country, of this society. You're on your own. My perspective, shared by many in this country and this state, entails quit. We're in this together. If not, then delete united from our country's name. I, for one, believe in a united States for all our citizens. That's the American way. Thank you.
Good evening, sir.
Thank you, Senator, and the panel for being here. I want to have my comments, but I have a question to ask for clarification about the law. So I'll ask it, but I'll ask it again at the end so that when you can answer my question, it will be part of my time.
Okay.
The question is going to be, how does this law affect the state employees that are going to be watched if this law passes, if they're violating the law, if citizens call and ask for help and information about how they get insurance? So if I could ask that question at the end and have y'all answer that, I'd like to know. I've been a substitute teacher for the past 12 years. I've been substitute teaching in both districts in Dorchester County, Charleston County, and in Berkeley County. And just this past Monday, I was substituting for another social studies class, as I've done many times before. And there are a lot of things that are being taught to 8th grade social studies students that don't seem to apply anymore since the Citizens United Supreme Court ruling was upheld. And what I want to do at this point is just to read briefly what these 8th graders are being taught about our government as being a republic rather than a democracy. They're being taught that the founders were influenced by the study of history. Over 2,000 years before our nation began, there existed in ancient Europe a government which greatly influenced the ideas of our founders. This was the Roman Republic from 509 BC to 27 BC, before they had Caesars. Its capital was Rome. It was located in what is now called Italy. Some of the ruins are there still today. The founders were influenced by what historians have written about the people and the government of the Roman Republic. They read that during the Republic, the Roman people governed themselves without a king. The common people and the aristocrats, and then parentheses, wealthy upper class, shared their power to govern. The people chose leaders to make and administrate the laws of their country. Our founders called the government a Republican government. They defined a Republican government as a type of government in which citizens have the power to govern. The citizens give powers to leaders they elect, represent them, and serve their interests. Also, representatives are responsible for promoting common welfare. And in parentheses, it says the good, entire.
Could I have you for a minute, sir, and get your mouth closer to the microphone?
Sure.
Yes. Okay.
And this common welfare has been worded in the preamble and in Article 1, Section 8, of being promote the general welfare. The founders thought that the republic government was possible in Rome only because of civic virtue of the Roman citizens. Civic virtue meant that both citizens and their leaders lived modest lives. They worked hard and they put the common welfare above their own selfish interests. They believed that the benefits of the republic government were the laws made by the representatives elected by the people would be fair, it would serve the common welfare rather than to serve the self-interest of one group, and that the people would have greater freedom and be able to live secure and comfortable lives. The founders thought a republic form of government was the best form of government they could create for themselves. And they could have the same benefits thought that the ancient Romans had enjoyed. Just two more paragraphs. Examining civic virtue. The founders thought that civic virtue was important to make our government work properly. Civic virtue meant that people would put the common welfare above their own interests. The founders believed that sometimes people might not be willing to give up their own interests. However, they hoped that people would still be kind to others, be willing to help them, and be concerned for their welfare. They thought the family and the religion were very important in teaching children how to behave in a way that considered the interests of others. And that reminds me of what Jesus said to his disciples: when I was hungry, you fed me. When I was naked, you clothed me. The disciples asked him, Lord, when did we do this? And he said, when you did it to the least of these. So I'm not going into this book about nullification during Andrew Jackson's time. He was a fellow Lancaster County resident, as I am, was, and a Presbyterian scholar. But he had to deal with the same type of thing, like you said, 108 years ago. And look at the disastrous results that took place. It only delayed the Civil War by 30 years. Back to my original question there. If this passes, and according to the newspaper, it said that state employees would not be able to discuss or promote anything as far as the insurance.
Obamacare.
Yes. How will that affect? Are we going to have watchdog things over citizens? I mean, the employees in the state government? Will someone that calls and asks for help, will the person on the other end of the line that has answered the phone saying it's a good day in South Carolina, but then has to tell them, I'm sorry, I can't help you. I may be charged with a criminal offense or something if I assist you in attaining insurance?
I mean, in terms of the enforcement of laws, the only thing I can say is the executive, the governor, is responsible for its full and faithful execution. So, I mean, it would be the prerogative of the governor to make sure that that law was faithfully executed. Now, how she would go about doing that, we really don't have time to explore right now, but it would be the governor's responsibility to make sure the law was executed.
So it's possible we could be making criminals out of our state employees if this law passed, and they are found to be in violation of this law?
I don't think there's a crime. There's no criminal penalties. These aren't criminal statutes.
Okay. Well, also under the Affordable Care Act, on page 131, it states that the IRS has no powers to bring civil or criminal charges for anyone who does not pay the $95. So it really means that there's no enforceable way of
that book is being taught in the public schools in Charleston County?
This publication is a project of the Center of Civic Education funded by the U.S. Department of Education by the Act of Congress established in 1987 under the permission of the bicentennial of the United States Constitution during the second term of Ronald Reagan.
I guess what I'm asking, you're saying that that's being taught in the
Yes.
schools today?
8th graders.
The other thing I wanted to do was thank you for quoting, I think it was from Matthew 25th chapter, because I think that's what this all boils down to. And to answer your question, in my opinion, you're absolutely right. If this H3101, if this bill passes, there's a section that says it prohibits the enforcement of the Patient Protection and Affordable Care Act. So to answer your question, the bill actually says that no agency of the state, officer, or employer of the state acting on behalf of the state may engage in an activity that aids any agency in enforcement of those provisions of the Patient Protection and Affordable Care Act of 2010, and it goes on and on. So I think you're absolutely right. If this bill passes, no state employee or state agency can do anything to help or aid in the carrying out of this bill. So I think that's
That's what I had interpreted.
I thought your question would go with crime. I mean, certainly it would prescribe that behavior, but it would not make it a crime.
If you said that they can't do anything to assist, then how are you going to enforce that?
Discharge, I would imagine. I mean, again, it's executive branch would have that purpose. Anyway, let's move to the next speaker because we have a lot.
I bet you will.
Sure.
Just a brief comment, and these first two speakers we've had tonight are kind of hitting on something that I've been trying to talk about last night and this morning in Columbia. My question has been in this whole thing is, if we pass H3101, what's the next step? What are we jumping into? And there's a lot of unknowns about that. And I think this committee needs to be thinking about that, whether or not this bill passes, because we're going to hear from folks tonight who are for this act and against it. We know something that's been polarizing in this country and something that's been divisive. But it's also something that's passed and has been upheld by the highest court of the land, the Supreme Court of the United States. You can't deny that, that's fact. So my question is, if we're going to stand out alone on this and nullify the ACA in the state, which is what it is. I mean, it's rendering the Affordable Care Act void in South Carolina. That's what this bill attempts to do. If we're going to do that, where is it going to land us? And the first woman who spoke, she commented that we're spending taxpayers' dollars going around the state right now to hold these hearings. It's true. But I'll tell you something. The money we're spending having these hearings is going to be a pittance compared to what's going to happen when the Attorney General engages the state. And we spend probably millions of dollars. Millions of dollars, on litigation that we can't win. We've seen it before in the state. That's something I think we need to look at. If we're going to be responsible legislators, we've got to think about these things. And some folks would tell us, that providing Medicaid is not a function of the federal government. Well, right now, the federal government does match a lot of our Medicaid dollars here in South Carolina. In the area that I'm from, rural South Carolina, a lot of folks depend on Medicaid. So if we opt out or refuse to acknowledge the Affordable Care Act in the state, and the feds, I don't know what they might do. If they decide to start taking away our matching dollars from Medicaid, people are going to lose that. And some people might say, well, that's a good thing. But we still got to deal with it. And that's what I'm wondering. That's what I want this committee to hash out. If we do pass this law, H3101, if it is signed into law, where is it going to land? What's going to happen next? I think we need to look before we leave. Thank you, Mr. Chairman.
Thank you. Speaker on the block here is Andrew Patterson. Patterson.
Can I use this podium?
I think that's also working. I think hold close to you.
Well, that's going to be a tough act to follow, that last one. My name is Andrew Patterson, and I'm a recent law school graduate and soon to be a member of the South Carolina Bar. And I also have a degree in history from Hampton City College. And I didn't realize tonight, I thought maybe this might be a referendum on Obamacare perhaps, or the Affordable Health Care Act. I think the very fact that we are here tonight discussing H3101 H3-101 kind of speaks for the fact that, we are clear what South Carolina's position is on that, the Affordable Health Care Act at this stage. And in talking about the bill, the way I read the text of H3-101 as it stands right now, does the title not introduce the bill, and I quote, "so as to render null and void certain unconstitutional laws enacted by the Congress of the United States."
It does, and that's why the prefatory language in this bill and the whereas clauses and the introductions as to why the House is doing what it's doing does use that language. For what reason, I think probably for public relations effect. But when you boil it down to the four provisions, the four things that are actual statutory enactments, those are the four things that it does. So in reality, there's a disconnect between that prefatory language you're talking about in terms of the whereas, whereas the 10th Amendment reserves under the state certain powers, and whereas the federal government's powers are enumerated, and whereas we believe that the Congress exceeded those enumerated powers, now therefore, but when they get down to the four things that they actually pass, I guess my point was, it doesn't do any of those things. It just simply, there is a disconnect there, you're right to know it.
Well, I think that's a very dangerous disconnect. I mean, I'm speaking to a panel of lawmakers
Yeah,
here.
no, it's-
Words matter. When courts look at laws, words matter. Senator McElveen, you asked, what is the next step? Well, if somebody's looking at this bill down the road, and the preparatory language talks about nullification, I mean, you can call it what you want, but when you have that sort of language, the idea of nullification, picking and choosing what federal laws that you would, as a state, choose to enact, I mean, that is, excuse me, nullification. There's no way around it. You can call it interposition, but it's essentially nullification, and I just don't understand that being in this state, in this city of all places. The idea of nullification, has a very colorful history here, and if you really look at the legal and historical framework of nullification, it came out of the Virginia and Kentucky resolutions of 1798. And again, that was a time and place specific context where you had these alien and sedition laws that were passed that deprived citizens of their liberties. And at that time, before Marbury versus Madison in 1803, you did not have a strong judiciary branch, so it was left to the states to decide. The states to decide whether or not a federal law was constitutional. But as any historian or legal scholar knows, in 1803, the judiciary carved out that role for itself in Marbury versus Madison. So the idea that today there is still this power by the states, 10th Amendment aside, to declare a federal law unconstitutional, I just don't understand it. I mean, I guess we read the same books, but we look at it differently. I'm familiar with the Prince case you mentioned, and there are certain parts where when you're actually getting the state to carry out a federal law, there are certain things that state actors can do in that sense, and certain things they cannot do. I think it's important to look at Reno v. Condon in that sense, the state's own attorney general at the time. And that case was 9-0. There were no dissenting opinions in that. They specifically said that you cannot do that. And that case, very clear. So I just think, you can call this bill what you want, but, preparatory language aside, language does matter. And in effect, that is what the bill does, whether it specifically says in the actual text of the bill that, it is actually nullifying something. I mean, it may not be doing it directly. I think it is, but that's a different subject. But essentially, it's gutting it. And I'm honestly not a fan of big government. I am actually not a fan of the Affordable Health Care Act. But the idea of nullification is just terrifying to me. 181 years ago, this very month, in this city, people were talking about nullification when they had a new tariff passed in Washington that did not agree with the citizens of South Carolina. Now, the same day the Force Bill was passed in 1833 by Andrew Jackson, South Carolina withdrew their bill, which would have nullified the tariff. So they did get what they want, but it's important to remember that generation of folks who in the 1830s thought they got away with nullification, they gave birth to the generation 30 years later who thought it was a great idea to secede from the Union in December of 1860 and then fire on Fort Sumter in April of 1861. So call it what you like, this bill just on its face is very troubling to me. And, whether it actually does specifically nullify the whole bill or challenges certain parts or, on its face or once it's implemented. I think a lot of thought has to be given to what this bill really does and what the next step is, because if you've already looked at one federal law you don't like, I mean, how far up can this thing go if H3 101 does pass? I mean, what's the long-term strategy? And that's really my view.
I think you make an excellent point, and the bill that we have before us, H3101, again, is not something the Senate has any chance to amend or to revise or to do anything with. I mean, it's the bill that passed the House, and it's the bill that's on debate right now. I think you made some very valid points in regard to the disconnect between the whereas prefatory language and then the actual statutory language that follows. And that's exactly one of the reasons why, I think this committee was appointed by the President pro tem of the Senate, is to look at this bill, to examine how it's constructed, to look at the language, and to report back to the Senate our findings. So I think your comments are very well made, sir. Thank you. I appreciate your comments.
Thank you for your time.
Thank you.
Good evening, gentlemen. As Senator Davis and Senator Bryan well know, I served 13 years in the Senate for new members, and I have 8 points I'd like to cover quickly that might give some ideas that had not been considered. First of all, I listened as best I could to this gentleman that spoke previously, and I'd like to point out that there's more than one way to skin the same cat. You can literally do something one way and it's prohibited, but wind up the same place doing it another way and it's perfectly permissible. The U.S. Supreme Court has said that the federal government cannot commandeer our states and our local governments to make us implement their policy. So I think wording matters, but it matters also in that it enables us to do some things to, in effect, gut or nullify what we oppose without coming out and saying we nullify it. But we're going to dare in the same place. Now, everybody's got their own tolerance level. What if the federal government passed a law saying you've got a quarter troops? So they're going to house troops in your house. Well, we would all oppose that. What if federal law took your guns? We'd all oppose that too. So everybody's got their own place where they would have civil disobedience. Now, the second point I'd like to make is, I think it is possible for the legislature to tell the Attorney General what to do. In fact, our state entered the tobacco settlement only because of a bill introduced by me, or as a concurrent resolution, to require the Attorney General to enter it. Our state Attorney General was not entering it. Now, whether it's good policy or not to do it is another issue, but I'm just saying the legislative branch tells the executive branch how it's going to spend its money and what its policies are going to be all the time, and then they're supposed to implement it. Now, thirdly, I would like to point out just very quickly some other options that might be incorporated into this bill or in other bills. The whole idea is the reason we have this Affordable Care Act is there was a void that wasn't filled. Now it's filled with something that we oppose. So we got to not just oppose it, but we got to come up with something to fill the void and substitute for it. And in my view, opening up the markets, having competition is a way to do that. Now, for example, there should be some mandate somehow of prices charged by medical providers in advance. The Post and Courier did a study of the prices of medical procedures here, showed widely differences in the amounts. I think the Medical University of South Carolina had clearly the highest prices, and there's no apparent justification from the article for these differences. Well, if people do that in advance instead of getting their medical care and then getting the bill and then getting sticker shock, that would be very beneficial. And I might add, in some places, like in Oklahoma, the University of Oklahoma cut their prices and advertised. I saw this on 60 Minutes. People fly into those states because of the cheaper prices. So if we had disclosure of prices, then people would have the tools to shop. Secondly, we should have buying insurance across state lines. Now, why is it that I can only buy an insurance policy in South Carolina? If I happen to find on the internet one in Montana or Nebraska that suits my needs, well then I should be able to do this. That bill was introduced and sent to the Banking Insurance Committee last term with the language thought out. So I'm just calling that to your attention. The concept that I think is the most profound in terms of benefiting our citizens was embodied in Senate Bill 1028. What it did is it enabled healthcare providers to contract directly with companies and individuals to provide healthcare and not have it be considered insurance. Now, we've all heard of prepaid legal. When prepaid legal started, it was very slow when it started in the 70s because prepaid legal was defined as insurance. And states one by one passed laws defining prepaid legal as not insurance. Our South Carolina passed it in 2003. This Senate Bill 1028 just took a prepaid legal bill and made it prepaid medical. It was on the front page of the Post and Courier last week that Palmetto primary care physicians, the biggest healthcare physicians, I guess, around here, is going to self-insure starting January the 1st. So they ditched Blue Cross Blue Shield. And they said that in January, they're going to start offering contracts. In other words, if I can't afford $800 a month for my family, for example, why can't I come to a healthcare provider and say, but I can afford $300 a month, so how much could you give me? Or why can't Boeing or Piggly Wiggly say, this is how much we're willing to pay on healthcare? And all you companies out there, tell us what you're willing to give in return. Or, this is what we need, tell us how much it's going to cost. That would be open competition, and that's what that Senate Bill 1028 would do. I think the health interstate compact was passed by the Senate last term. And it should be passed again. At least 15 states have passed this compact. Our Constitution allows states to enter into interstate compact. There's over 200 of them. If they entered into an interstate compact, essentially abolishing Obamacare or nullifying it, then all it takes is Congress to approve the interstate compact and it becomes law. Now, you'd say, well, why would Congress approve an interstate compact abolishing Obamacare or the Affordable Care Act if we're not getting it through now? Well, the reason is if the majority of the states pass the interstate health compact law, then all those states, federal legislators from that state are going to be under pressure to do what their state legislature passed. So this is a way state by state at the state level to agitate to get the laws passed. Again, 15 states have already passed it. And it doesn't go into effect unless the majority of the states, unless the Congress. So the last thing I'd like to mention is medical malpractice. Now, you remember in the Senate last term, we passed a law that says it's tort relief if you burn leaves or stuff in the back of your yard and the smoke causes a wreck, then you can't be sued for negligence if you can prove that the following, that the stuff was burned in accordance with regulations yet to be determined, by the way, by the Department of Forestry. Now, there's a lot of medical procedures, I've talked to doctors about this, where you can put into a computer and say, well, given these circumstances, should this test be given or that test be given, yes or no? And not everything, but you basically come down to you definitely shouldn't give this nuclear test, you definitely should, or it's uncertain. And instead of having a jury on an ad hoc basis determine what the standard of care is on these medical malpractice cases, we can literally have experts come up with a checklist for a lot of standard medical procedures, have the legislature say, if a doctor can prove that he did those, then that's the standard of care, and we're not going to put before a jury on an ad hoc basis what the standard of care is. Now, if we can do that for burning leaves and forestry, why can't we do it, assuming it's technologically feasible, with regard to medical care? Thank you for listening.
Probably Probably the reason we can't do it is because my wife's in St. Francis Hospital with a heart condition this week, and she's been in a rather poor condition to negotiate the price of her treatment with her doctors or check the internet about what tests she needed. Thank God, if we're going to negotiate prices, it'll be about insurance. 150 years ago this month, my ancestor William Evander Finkley stood on Missionary Ridge in the state of Tennessee with the 10th South Carolina Infantry wearing a hat like this one. The army of Ulysses S. Grant came over that hill, and my ancestor rejoined the Union. Unfortunately, he had a bullet in his left leg by the time that happened. The Yankees took him to prisoner of war camp, and he had his first experience with a federal health care program. And they did a good enough job that in 1865, he was able to walk home to Pamplico, South Carolina, where he built a home, he built a church, he built a school, and he built a town. And he did that as an American. And since that day, my family have been citizens of the United States of America, and we value every right and privilege of that, including those that we have under the Affordable Care Act. This is a very poor and embarrassing law. I am shocked that in 30 minutes of discussion, the men and women that represent us in the legislature have not mentioned that 250,000 people did not receive a Medicaid expansion, and that 1,314 of them will probably die next year. I did not hear in the 8 proposals just made a single one that will help the kid driving the carriage on Market Street today that I told about Obamacare, how he will ever get health insurance. He's not going to be able to take his $800 to Montana. He doesn't make that much a month. He needs a subsidy. And this law stands the risk of standing between him and that subsidy, which means if he falls off that carriage and he goes to the hospital, oddly, all the conservatives that hate socialism are going to tell me that my wife's hospital bill this week at St. Francis should pay for that carriage driver's medical care. This is a better law. My friends and I have drafted. We invite you to help us draft it. We invite you to adopt this law. This law says the people of South Carolina will stand together against disease and death and suffering and bankruptcy and privation and poverty. It says that the employees of our state, its school teachers, the people that run its clinics, even the men and women that represent us in the legislature, unlike Lindsey Graham's office that says, if you've got problems with the health care law, I don't care. That's what it says. The phone message says, this says that every part of our government will help people obtain all of their rights under this law. This law, the Healthy South Carolina Act, a law of which our state could be proud, says that we will accept the funding for Medicaid, which we could have already done today. People that are earning between $5,000 and $11,000 a year, like one of my clients today who might get subsidies and will probably be helped, who works 2 jobs, 50 hours a week at $9 an hour. She is not a slacker. She is not a taker. She is not lazy. She goes to church every Sunday. For the first time in her life, she'll be able to afford to get health care. That was working at the candy shop on Market Street I talked to today about Obamacare, who gets nothing because he earns less than $11,000 a year, will get Medicaid. And the last thing in this law says that beginning with this legislative session, that our governor and our Senate and our House will convene a commission to begin a process not of implementing the Affordable Care Act in South Carolina, but of going beyond it to establish laws, regulations, and provisions that will assure that within a decade, not a single citizen of the state of South Carolina will face disease or death unaided and alone. And that is the type of law that is worth your time in Columbia. That is the type of South Carolina for which my ancestors fought, and of which, despite their mistakes in history, of which they would be proud. And this blood, which stood on Missionary Ridge in a Confederate uniform, stands before you today to say that that is a South Carolina worth fighting for. South Carolina is part of the great United States of America, a proud, contributing component of a great nation. I'll say one more thing to you before I leave. Behind me sits a lady, Laureen Matheson. She's wearing a dark hat. Your employees won't help people get health care. Your clinics won't. Your governor won't. Lindsey Graham won't. Mark Sanford won't. Maureen will. People, confuse people, people who have heard every conceivable lie in the media and from elected officials, and patiently answer their questions, help them fill out a form. And even though the website isn't working, Maureen is.
Right.
And then we get a stamp on it. The greatest nation the world has ever seen. The one which landed on the moon, that crossed the continent with rail, that joined the Pacific and the Atlantic at Panama, a nation which does great and wonderful things. And when we put a stamp on it and it gets processed, those people then can see a doctor. They can then go to the hospital without fear. They don't have to fear it. Now, sir, you don't have to do what I asked you to do in Columbia. You don't have to respect what I believe. You can, this state can continue to embarrass me with its venality, its cruelty. This much I can promise you. If you wish to do nothing, that is the state's privilege, perhaps. But if you come after my friend and our fellow navigators, I pledge this, sir. The blood which stood for the state of South Carolina on Missionary Ridge will fight again.
Shelley Quint. Did I pronounce that correctly now?
It's Quenga. That's okay. I'm Shelley Quenga. I'm the Director of Programs for the Palmetto Project. We're a statewide nonprofit who's been working on healthcare access for more than 15 years. So we've been working with uninsured folks in our state for many years and hearing their stories. And although I'm heartbroken that our governor did not approve Medicaid expansion, I hope that you will be strong enough to do that so that our folks can have health care, because I have to go out and talk to people and tell them that some of them are too poor in our state and that our legislature doesn't care enough about them to make a decision to get them health care. The money that you set aside for little health clinics and for hospitals is still only in some areas. So even though you took money and that could have been used for the Medicaid expansion administrative costs, and you've made that available for health care, but still only to a limited population, with no rules or regulations about how that's to be distributed so that people who are uninsured can actually have some access, although it will be minimal. It is true that people can go to an emergency room to get a Band-Aid on something. They don't have access to specialists. I have a young man who calls me from Denmark who's been bleeding from the rectum for over a year. He's 20 years old. He's going to college. His parents don't have insurance. So he doesn't have the opportunity to stay on their plan, even though the Affordable Care Act allowed that for many people. And he goes to the ER and they say, "I'm sorry, we don't know what's wrong. We think you may have colon cancer, but you need a colonoscopy." That's not something we do in the ER. So this young man will likely die because we don't care about people who are too poor to have health insurance. And it should break your heart that a young man who's doing everything right doesn't have access to care. Palmetto Project has 9 certified application counselors, which means that we can also help people with access to marketplace coverage, because we believe that it is a right to be able to have information to make an informed decision about your health coverage. Had research conducted by the University of South Carolina, which was funded by our own South Carolina Medicaid agency, to ask Medicaid beneficiaries, what kind of information do you need about your options for health care under the Affordable Care Act? Who would you get it from? What format did you want it from? 43% of those people said they would call a state agency. That means those people under the act that you're proposing would call a state agency and would not receive information. But I have to tell you that there are people in your state agencies already who are working with money that was provided by the Affordable Care Act to do things like streamline our Medicaid application. What used to be a 6-page application is now a 3-page application. What used to be an application on paper can now take place online. When people didn't have help, now they can get help to understand how to get Medicaid in our state. That's because we have a system now that's been funded by money from the Affordable Care Act that works better. So I would hate for my friends at the Medicaid agency to lose their jobs or to not be able to help people because the money that they're using is from the Affordable Care Act. There are also folks who have received Affordable Care Act money, sir, since 2011 to do work on obesity prevention, smoking cessation in our communities around the state. That's all Affordable Care Act money, sir. It's already in our state. And our folks are already working on that. So I would hate for my friends also at DHEC to be prohibited from doing the job that needs to be done to keep our people healthy. That's what a public health department does. But they need funds to do that. And right now those funds come from the Affordable Care Act. So I want them to continue doing that. If they have healthier people, then I have less people that I have to work with who live outside the system.
Thank you for your comment. Reginald Williams. Good evening, sir.
Good evening. I want to thank y'all for taking the time out to listen to the citizens. And I know y'all have a pretty busy schedule. Oh, I'm sorry.
Get close to the microphone, sir. Yes.
Like I said, I just want to thank y'all for taking the time out. The gentleman, Senator Johnson, he did express his opinion on the proposal that's being done today. But I'd like to hear from the other gentlemen, would you support the proposal as it is written right now? Yes, all of them.
There are aspects of A3101, yes, that I do support. I do not think that the resources and personnel of South Carolina ought to be implementing a law that I think is damaging to this nation, in my opinion. I do think that the Attorney General, as the implementation of Obamacare goes forward and regulations are promulgated, if they impact South Carolina negatively, I think the Attorney General should take action in that regard. I do not think that South Carolina should create a health care exchange because I believe that is the mechanism under the Affordable Care Act whereby the IRS levies fines and penalties and issues the subsidies. I do not think it's in the best interest of South Carolina. I don't think it's in the best interest of the country for this reason that you asked me. Because I wasn't going to offer opinions, but you asked me a question. Our country is now over $17 trillion in debt. For the last 4 years, it was over $1 trillion annually in a deficit. We just got below $1 trillion for this last year. The problem's even worse than that, however. How do you think we function each year at $1 trillion deficit? What happens is the Federal Reserve, well, first, what happens is the Treasury goes into the marketplace, sells bonds to primary dealers like AIG and JP Morgan that buys bonds. The government has the money to make up that $1 trillion deficit. The Federal Reserve prints and creates new money to go ahead and buy those bonds. We've quadrupled the monetary base, in the last 4 years. We have a debt of $17 trillion and there's no end in sight. Everything you're talking about today, everything we're talking about in government, all the services, everything in terms of what's good for people, it's hard to argue against that, but who pays for it? What happens when our country goes bankrupt? What happens when the creditors of the United States don't lend us money anymore? What happens when we start defaulting on our obligations? This can't go on forever. We have seen the deficit explode. We have seen the debt explode. If we could just go ahead and continue on like this forever, we wouldn't have an issue. But it can't continue on forever, sir. That's why I do not support the expansion of an entitlement. That's why I don't support it, because we can't afford it. My daughter would like to buy a whole lot of things my wife and I can't afford to buy for her. And she can make an argument all day long about how her life would be better if she had that. We can't afford it. Now, we have to provide more health care and access for our citizens. I don't accept the premise, though, that the federal government, of all entities, is the answer to that problem. I don't think the federal government has the ability to come up with an answer for those problems. I think it starts with individuals. I think then it goes to the community. then it goes to states. I don't want to start with the federal government. I personally don't think this is the right answer to a very real problem.
Mr. Williams, the H 3101 in its current form, I support the provisions in it. I don't support other provisions. I don't support the language, as I think it was Mr. Patterson pointed out. I don't support the language that talks about nullification, because that is not at all what the substance of this bill does. So I think it's misleading and it's confusing, and it needs to be removed from the bill. I think a lot of the prefatory language is just, it's a lot of fluff. It doesn't have any substance, and I think a lot of that needs to be cleaned up and taken out. The language about the Friends decision, that's the law of the land. That's a restatement of current law. So it's really not it doesn't really add anything to the equation. It just sort of restates what is already the law. The language regarding the Attorney General's encouragement to somehow bring actions as a result of Obamacare, that I don't believe that provision is intended to add an additional legal cause of action. I think what it's trying to say is that current South Carolina law, if there are under current South Carolina law, if there is some provision that under current South Carolina law, the Attorney General could bring an action, that he's got the authority to do that, but he's got that authority now either way. So I think that language needs to be cleaned up, but you'll probably leave it in there. I do not agree with the income tax deduction for paying fines and taxes under Obamacare. I think that's having the people of South Carolina support. It shifts the burden of paying for Obamacare to the citizens of South Carolina, which I don't believe is appropriate to the taxpayers, all the taxpayers of South Carolina. And then finally, the language regarding state exchanges. The governor has already refused or determined not to set up a state exchange and go with the federal exchange, and that's the current. Once again, that's the current state of the law. In South Carolina just restates that law. So, as I say, there are pieces of it I agree with, pieces of it that I think should be changed. And, but that's, we're very early in this process. I've got to tell you the truth. Although we've had 3 hearings, and I've learned a lot at each one of them. They've all been very different. We've got additional testimony that we will take from legal scholars, from constitutional scholars, so we can proceed as my colleague Senator McElveen says, so we can proceed in a way where we don't lead before we look. We're going to take this prudently and carefully and thoughtfully, and at the end of the day, hopefully we will proceed to reach a decision that represents the citizens of South Carolina well.
To answer your question, sir, no, I will not support this bill as it's currently written. But as a personal legislator, one thing I try to do is keep an open mind. I have my personal feelings about things, but the way I approach the job is that I represent my district, people of the state, and I think that's why we're all here, is to get your input. We can craft this bill in a way that it does pass and does some good things, or it doesn't pass. I don't know what's going to happen with it. In general, I don't think it's in my job description as a state legislator to go around picking and choosing federal laws I want to take. What I found, since I got into politics, is that sometimes you get called a lot of names and you have to have a thick skin. One word that I like to be called, maybe when my service is over with, is a pragmatist. And that's what I aspire to. And like I said earlier, we talk about the Constitution. We can't use the Constitution as a sword and a shield all the time. If you respect the Constitution, you respect separation of powers, you respect the supremacy clause. These are things you can't ignore. And this has been upheld as a law of the land. My immediate concern is that, I said this twice earlier, in South Carolina, we don't deficit spend. We have a set budget. It's not so much a question of how much money is going to get spent, it's where it's going. And if we get engaged by the federal government in litigation because we pass this bill, we're going to spend a lot of money. And in my opinion, there's things about the Affordable Care Act that I don't like. And there's things, lots of things the federal government does that I don't like. I think the gentleman sitting over here, you know, he summed up my opinion, I think, much more eloquently than I could ever do it. And, you know, I think as state legislators, we'll go back to Columbia in January. This bill's on special order. We'll spend a lot of time on it. But that time might be better spent figuring out how we're going to fix these crumbling roads and bridges. It would not be better spent working on ethics reform that people are screaming for. It would not be better spent on comprehensive tax reform. It is time for comprehensive tax reform in this state. I think most of us can agree on that. Act 388 has caused a lot of problems with business communities, and it's caused problems at the local level. So these are things as a state legislator that I want to work on. I don't want to spend a lot of time taking federal laws out that I seek to nullify. If I want to change federal law, maybe I'll run for Congress, maybe I'll try to get on the Supreme Court. I don't have any instant plans to do that. I like where I'm at now. So I want to do the state's business and do the business of my district. So you know, I want to support this current bill.
But I just want to be clear, and I don't mind saying that I do not support this bill. I see all the problems with this bill. You know, and the biggest thing I see is that I don't even think this bill is going to meet the test of being constitutional. I think we have to still realize that we've had president after president after president since probably Harry Truman that have tried to pass a national health care bill. President Obama comes along, it passes Congress, he signs it. It goes to all of these challenges leading up to the Supreme Court. The Supreme Court says, except Medicaid expansion, that the bill is constitutional. The president was re-elected, and then we come up with, I think it's just a backdoor way to try to figure it out. But I'm also concerned about the livelihood of millions of United States citizens and hundreds of thousands in South Carolina who don't have access to affordable health care, who have some serious health care issues. And I guess my question is, how do you put a value on a human life? This bill, in its current form, where it's going to allow for tax deductions that we found out this morning in Columbia, will cost the state as much as $90 million. Where does that money come from? Does it come from schools and roads and bridges, whatever? So I think that we've heard a lot, and we will continue to hear a lot, because I understand that everybody have their opinion. But as I said earlier at another session, we keep hearing a lot of opposition. And one thing I have to say about Senator Rose, I know he's gone, is that we're not hearing much of, well, I don't like it, but here are some other options. He gave us some options, which are good. But I think if we just say we oppose the Affordable Care Act, then what about all of the citizens in our country who actually need health care, who need insurance? Do we just say go somewhere and die, or what? Right. So I think we need to look at and I think we can come up with that. And you know, 17 trillion is a lot of money, but you know, I don't want to deal with the deficit on the back of people who are sick and who need affordable care.
I want to thank y'all for all y'all opinions. It helps me to understand how this bill is being forward. And I think that's extremely important for anyone to understand. Me personally, a couple of things come to mind. I've always been taught, when you know better, you're supposed to do better. And it brings on the second thing, is that if you say something, you're supposed to do it. You don't say something and don't do it. When you take an oath to protect the laws of the state and the United States of America, if you don't want to do that, then don't take the oath. This is the law of the land, whether we like it or not. Amen. So, since this is the law of the land, you have to protect the laws of this state and this country, then that's what we got to do, folks. I mean, it's just that simple. Yes, I believe that we can actually work around the financial issue. And speaking of the budget, if you actually look at some of the reports, the budget has been coming down in his presidency and over the past presidencies, as far as the federal budget is concerned. Now, of course, you may have didn't like me about the state budget, but then, however, I feel that I served 8 years in the Marine Corps, all for the love of my mother and the freedom that she fought during civil rights time. And I would actually hate to see our state, because I love the state. I left at one point and I came back. I just hate to actually see our citizens go without health care. It's bad enough that we got a lot of our citizens that's on the street asking us for, one time they used to ask me for a penny, for a nickel. Now they ask me for $5 now. You know, and there's no excuse behind this. We know better. Since we took the oath to protect this state, to protect the laws of this land, then we have to stand by what we say. We got to say what we need and mean what we say. That's my opinion.
Good evening, gentlemen. I just want to say I sincerely appreciate Mr. Jones' remarks about the fact that you all swore an oath. And Senator Davis, my question was, first off, to you, did you swear an oath to uphold the laws of this state and the laws of the United States? To clarify, I want to make sure that, did it specifically say to uphold and protect and defend the laws of this state, or was it protect, uphold, and defend the Constitution of the United States? The Constitution? Okay. So, to clarify, your oath was to protect and defend the Constitution against enemies, foreign and domestic, not state laws or federal laws, but the Constitution.
The oath is at this Constitution.
Thank you for clarifying. Undoubtedly, there's a ton of emotion wrapped up in this debate because we're dealing with the most integral, parts of our life. It's our health care. And obviously, we all have a vested interest in this fight. But it's important that we understand it's not about whether these are good ideas or bad ideas, but what's constitutional. And it's important that, for instance, it might be a good idea to find a way, if your children are starving, to get money, but robbing a bank to do that is not lawful or moral. That's a bad idea. To break the law in order to do something good with it is not a good idea. And I would suggest that what we're doing now is with H31, the proposal that the House went through, and what you're going to consider amending in the Senate. It's not about picking and choosing which laws that we like or which ones we dislike, but which ones that we believe are usurpations against the Constitution of the United States that you swore an oath to protect and defend, not only from enemies foreign, but domestic. And so that's possibly, Congress that has overreached. It could be a potential enemy of the Constitution. And the next question I want to ask is, in Article 3 to get to the brass tacks of the matter, I guess the question is, who decides what is constitutional? And I understand that it's been a long-running precedent that the Supreme Court has been considered to be the ultimate arbiters of constitutional questions. But could you tell me and clarify in Article 3 of the United States Constitution which clause or section grants the authority of the judiciary, the Supreme Court, to strike down laws by Congress, passed by Congress?
I believe Chief Justice Marshall implied that power. I do not think it's expressed at all in the Constitution.
Okay, so it's not enumerated in the limitation of powers for the judiciary outlined in Article 3 of the Constitution that says the Supreme Court is the ultimate arbiter of constitutional questions of laws passed by Congress. I understand that since 1803, the case of Marbury versus Madison, Justice Marshall assumed these powers in establishing the doctrine of judicial review But do you recall in this case of him citing which section, which clause of the Constitution in Article 3 that granted him the authority to establish judicial review?
There is no such law.
Okay, and so I think it's fair to say, although it has been a long-running precedent, that Justice Marshall implied and declared that the Supreme Court is to be the final say as to what laws are constitutional. He did not cite authority in the Constitution that he swore an oath to uphold and protect. And so I would consider that a usurpation of the authority that was granted to the judiciary. And it's important that we understand that even the founders of the Constitution, Alexander Hamilton, for most historians, we understand that he was one of the biggest Federalists out there. This man was not a ultra-conservative. He wanted a king at one point. But he even said that the judiciary branch is by far considered the weakest branch of the federal head. He said it doesn't have any power over the purse or the sword, meaning enforcement. They have opinions, and it's important. In Article 3, Section 2, it says, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and regulations as the Congress shall make. And so it's clear that Congress, they are subservient to the regulations put forth by Congress. Thomas Jefferson, another father of the Constitution, was quoted in saying that if we were to consider justices of the Supreme Court to be the ultimate arbiters of constitutional questions, that would place us under the that would place us under the despotism of an oligarchy. He said he considered that a very dangerous doctrine. He said that the Supreme Court justices have with others the same passion for power, for party, and for the influences of their courts. He went on to say that the Constitution has elected no single tribunal. And so it's important that Thomas Jefferson said to consider the 9 men that are on the Supreme Court as the ultimate arbiters of constitutional questions. That's a very dangerous doctrine. Okay, I think we need to remember the words of the man that helped craft the legislation. So ultimately, what could we say? Who is the ultimate arbiter of constitutional questions? And I would suggest that as the states existed prior to the federal government, that the states were the creator of the federal government, that the creature that they created is subservient to them. And I would draw the parallel to an employer and an employee. I don't think a wise employer, if he was to take counsel from his employee to the fact that the employee goes to his employer and says, I don't like the way you're running the company, I'm going to take charge, and from now on, you're going to give me the money, and I'm going to run things. And if you don't like it, tough. You're going to be subservient to me. I don't think that employee would be employed much longer after that. And I believe that's an accurate parallel with the relationship with the states, relationship between the powers of the state and the federal government, because the states created the federal government. And
With slaves.
And so what I would have to say is if we don't say no to the overreaches of the federal government, because I believe in the Affordable Care Act, if we read Article 1, Section 8 of the Constitution that enumerates the legislative branch's powers, a simple reading of the text would find no authority for the 159 new bureaucracies that are created in the Affordable Care Act that are now wedged in between the doctor and the patient relationship. I find no enumerated powers that constitute that authority to get invaded into our lives. However, I would suggest that we do need some changes in our healthcare system here. It's not about just saying no to the federal government. It's not just about saying no to people's needs and care. I think that historically, being a student of history, that private charities have always met the needs of the people the best. And so, historically, what I've seen when governments over time centralize their power, we see a trend, and it's called the nature of man. Power corrupts, and absolute power corrupts absolutely. Over time, these governments that have assumed all these extra powerful things these powers, it always leads to a tyranny. And so even if there's, and I'm not subscribing that large individuals that crafted the Affordable Care Act, but I would suggest that this starting point, by giving this extra authority, not enumerated in the Constitution, to the federal government, is open up to corruption. And I believe that it will continue to corrupt them. And what I would say is that H 3101, as it's written, I think needs to be strengthened. I believe that it is the duty of the state legislatures to erect the barriers. In Federal Assembly 85, it says that we shall safely rely on the disposition of the state legislatures to erect barriers against the federal encroachments. I believe that Article 1, Section 8 clearly shows that there's no provision for the Affordable Care Act, the authority to carry that out. I believe it's an encroachment. And it's your duty, you guys, it's your duty to protect South Carolinians against this, even if it's something that we like. It's an overreach. Then it's a slippery slope. After you break the precedent of violating the Constitution, what's next? If we were to rely solely on the Supreme Court, can you imagine several years from now, where does it stop? If we're beholden to the 9 men on the Supreme Court as to the destiny of everyone's lives here, what happens when they declare, because they've already declared that a baby in the womb is not a living person? What if they declared that a child to the age of 3 years old was not a living being? And so, I would suggest if they wanted to come and say that we needed to take our guns, when do we say no? When do the states stand up? And I'll leave you with a quote. Congressman Edward Livingston of New York said, "If regardless of our duty as citizens, as our solemn obligations as representatives, regardless of every sanction, human and divine, we are ready to violate the Constitution we have sworn to defend, will the people submit to our unauthorized acts? Will the states sanction our usurped powers? Sir, they ought not to submit. They would deserve the chains which these measures are forging for them if they did not resist." Thank you.
Thank you. We'll deal with any comments as we can now, as they come forward, and if we feel compelled to say something, of course, but I really want to make sure everybody has a chance to be heard. And so I'll move to the next person, Maureen Myerson. That's okay. Have your say.
Thank you. First of all, good news. The deficits are actually going down rapidly. Chuck, you'd like to take a look.
Because they dropped a little trillion.
Well, see, they're going down pretty well. As you may have heard,
You got to put that right in front of your mouth. Yes, ma'am.
It's not on. It's on.
The microphone is not on.
It's on.
The other
podium. The other one. Better?
Yes, ma'am.
Oh, good. Glad to hear it. My name is Lorraine Myerson. As you heard, I am an Affordable Care Act navigator, certified. I work for the Progressive Network in Charleston, Dorchester, and Berkeley counties. Thank you for the opportunity to speak. What's wrong with health care in South Carolina is not the Affordable Care Act marketplace policies. What's wrong with health care in South Carolina is that we did not enact Medicaid expansion. As a navigator, my job is twofold. I meet with civic groups and I provide information for them about the Affordable Care Act. I'm also available to meet one-on-one with individuals throughout these counties so that they can find out which policy will best suit them. And they can also find out what subsidies they're eligible for under the Affordable Care Act. The idea that citizens require legislative protection from the Affordable Care Act marketplace policies is absurd. The The Affordable Care Act protects all of us, whether we're insured by private insurance or insurance purchased through the marketplace. It protects us from discrimination based on pre-existing conditions, which, as determined by the insurance companies, affect 1 out of every 2 adults. I want to tell you very briefly about a family I helped last week. 2 adults, retired, they had worked all their lives, in their early 60s, so they don't yet qualify for Medicare. Both of them have survived very serious health conditions in the past. Because of those conditions, their health insurance to now has cost them more than $2,000 a month. Under the Affordable Care Act, even before subsidies come into it, the most they could be paying is less than $800 a month. And their insurance is getting better because of the provisions in the Affordable Care Act. Every day, I speak with great numbers of people who want to access preventive care that they need to stay healthy. I think I got almost 20 calls today. They are proactively attempting to ensure their health so they can be productive, tax-paying citizens of our state. Unfortunately, because we did not choose to expand Medicaid, unless an individual earns between 100 and 400% of federal poverty lines, they're ineligible for coverage. And in practical terms, as things stand, that means they're ineligible for care. Until we expand Medicaid, there will be thousands of people in South Carolina who are denied the opportunity for quality health care. People by the thousands are being disqualified because they're too poor for us to help. What's even more ridiculous is that right now, federal tax dollars that all of us, that everyone in the state of South Carolina pays out of every single paycheck, those monies are being sent to Washington, and those monies are being used to insure people in states all across the country. Except here. Except here. Except those states which feel somehow that we don't need it. We need it. What's wrong with health care in South Carolina isn't the Affordable Care Act marketplace policies. What's wrong with health care in South Carolina is that we have not expanded Medicaid. I ask you to please do so.
Thank you for your comments. Mr. Jenkins still here? Good evening, sir.
Thank you very much. I always enjoy the opportunity to exercise freedom of speech. Just a couple of questions. What is the alternative that the General Assembly may be offering in place of Obamacare? And what kind of health insurance do you all have?
I have private health insurance through my employer. And in terms of the alternative, it is following the lines that Mike Rose discussed in terms of improving the access to health care by breaking down barriers to companies providing services, prepaid medical plans, things of that nature that empower individuals would be the approach that I would take. But in terms of my insurance, I have private insurance.
Does the General Assembly offer insurance to the members of the Assembly?
They do, but I don't have it.
What kind of insurance do the other members of the Assembly have?
They have to speak to me. I don't know what they have.
I don't mind telling you. before I got elected, I worked for a law firm or something, and we have probably 8, 9 employees, a small group. We had a group plan, and I can tell you that, you know, knock on wood, and luckily I've been pretty healthy. I've not had any major problems. So the plan I had a high deductible. I was paying pretty good premiums every month. You know, and not using medical insurance all the time. But I didn't have to. Thank God for that. But when I got elected, I went on state healthcare plan, and I elected there again to have a large deductible policy with a health savings account. I was able to use my old health savings account that I had in my law firm's insurance, and I still have that account.